Hello friends, Namaskar. Myself is Dr. Jinesh Soni. I am an advocate. In today's class, we will study about Section 19 of Prevention of Corruption Act. I want to clarify that as far as the said protocol is concerned, there is a provision that while prosecuting a public servant for the offences under Section 7, 11, 13, 15 of Prevention of Corruption Act, there is a need of a valid sanction from the authority competent. Now the important question arises, who is competent authority as far as the said protocol is concerned? If you will peruse the said protocol, you will find that it may be the government or the authority competent. Means the authority competent to remove the concerned public servant from the position he is holding. So the law point is very much clear to us. If the sanction is accorded by the appointing authority and the said authority is not competent to remove the public servant from the office or position, in that scenario, the sanction would be illegal. Now I am going to emphasize on the important judgment of Honorable Supreme Court to sustain the importance of Section 19 of Prevention of Corruption Act. Please be noted. SLP number is 12708/2023. Title is Shivendranath Verma versus Union of India. In that judgment at inception, it is observed that in view of Section 19 subclause 1 of Prevention of Corruption Act, we do not think that the trial court was justified and correct in law in taking cognizance in absence of sanction by the competent authority. So we could say that if the sanction is not available, in that scenario, cognizance or proceeding subsequent thereto would be illegal, and apart from that, if sanction is not accorded properly, in the said scenario, the prosecution will ensure the same consequences. So in a nutshell, we could say that the sanction is required. Number two, it is required to be accorded by the authority competent to remove the public servant from the position. And if both the protocols are not fulfilled, in that scenario, the concerned proceedings would be nothing but abuse of process. And that's why it is observed by the court. The cognizance taken by trial court is not justified, and it is abuse of process, and it is not correct at law. So basically the court submitted that in view of the legal position, the cognizance and the proceeding subsequent thereto is liable to be set aside, quashed and rejected. But it is clarified by the court that in case a fresh sanction is obtained by the authority, in that scenario they may file the same, and concerned trial court could decide to proceed or not to proceed as per the available facts and circumstances. So I want to clarify that the said judgment is utilized by ACB or vigilance or CBI in those cases where there is a plea on their side that permission is to be granted to replace the previous sanction order, which is defective at law. I want to clarify that there are multiple cases wherein the sanction is issued by the authority, but it is defective at law. And that's why, to protect the prosecution from being vanished, the plea is taken in the light of said judgment. So I want to clarify that if sanction is issued, even though it is defective, it could not be cured. And apart from that, if sanction is refused, and after refusal, a fresh sanction cannot be issued on the same material. Defect cannot be cured by using that judgment because it is concerned with those scenarios wherein there is no sanction and sanction is yet to be issued. So if there is no sanction, the court can wait for the sanction, and even though the concerned accused is discharged and subsequently sanction is submitted, in that scenario the said fact can be taken into consideration and process could be issued accordingly. So I think that I am totally able to enlighten all of you on the important point that sanction once refused cannot be issued again. And if there is a defect in the sanction and it is issued by the authority not competent, in that scenario there will be a violation of Section 19 subclause 1 subclause A, B and C, and by relying on that judgment, the CBI vigilance could not have the benefit. So in case you are having the same trouble, you may enlighten the court with the help of said argument so that you could submit your side in a dominant way and could be in a position to vindicate your grievances as per law. See you in the next video. Till then, Jai Hind, Jai Bharat.